Late last night, something shifted quietly inside the legal system. There was no announcement, no televised statement, no immediate reaction from officials. But inside court circles, attention moved fast, very fast. A strategic move tied to Donald Trump began circulating among legal professionals, and the reason it stood out had less to do with politics and more to do with timing, structure, and what it forced the court to reconsider. Court strategies don't usually change overnight. They evolve slowly, shaped by motions, responses, and predictable schedules. That's why this moment caught so many off guard. It didn't fit the usual rhythm. It arrived at a point when many assumed the path forward was already defined. But assumptions don't hold much weight inside a courtroom. When a legal strategy takes a sudden turn, judges don't ask whether it's dramatic. They ask whether it alters obligations, whether it affects procedure, whether it introduces issues that must now be addressed before anything else can continue. That's exactly what began happening here. Inside the system, clerks started rechecking calendars. Pending actions were reviewed again. Internal notes were updated, not because a ruling had been made, but because the framework surrounding the case was no longer as stable as it looked earlier. This is the stage where the legal world reacts quietly. Not publicly. Experienced attorneys know that strategy is often revealed through timing, not arguments. When a move appears earlier or later than expected, or when it touches parts of a case thought to be settled, it changes how every participant prepares next. That shift alone can alter momentum. What made this moment especially notable was that it didn't force an immediate public response. Instead, it forced internal review. Courts had to decide what now required attention, what could wait, and what could no longer proceed under the same assumptions. That process doesn't happen on camera. Judges begin by isolating impact. Does this strategy affect deadlines? Does it interact with prior rulings? Does it raise procedural questions that could affect fairness or appeal later? If the answer to any of those questions is unclear, caution becomes the default. Caution slows everything. That slowdown doesn't mean nothing is happening. It means everything is being examined more closely. And when courts slow down, legal teams on all sides feel it immediately. Opposing parties don't wait for orders. They prepare. Drafts are reopened. Arguments are reviewed for weaknesses. Scenarios are discussed that weren't necessary the day before. Pressure builds without noise. This is why legal observers describe moments like this as turning points even when no ruling is issued. Strategy changes don't need public confirmation to have real effects. They ripple outward through preparation, timing, and risk assessment. The legal world understands this instinctively. Another important detail is that this shift didn't rely on emotion or narrative. It relied on structure. Courts care deeply about structure. When structure changes, even slightly, it affects how decisions must be made going forward. And structure is exactly what's now being reassessed. Inside judicial chambers. Discussions aren't about headlines. They're about order, sequence, responsibility. Judges are considering how to move forward without creating vulnerabilities that could be challenged later. That concern shapes every step. Silence from the bench at this stage is intentional. Courts don't rush to comment when they're recalibrating. They let the process settle into its new shape before making anything visible to the public. It may look like nothing has changed. Inside the legal world, it's clear something has. Because once strategy shifts, even subtly, the case no longer moves on autopilot. Every next step becomes deliberate. Every action is weighed more carefully. This is where experience matters. Veteran legal analysts aren't watching for dramatic rulings right now. They're watching for signals, small procedural moves, adjustments that indicates a court has acknowledged the change and is responding in its own way. Those signals often come quietly: a schedule revision, a delayed action, a request for clarification. None of these make headlines immediately, but all of them indicate engagement. And engagement is the real reaction. What happens next will not arrive suddenly. It will unfold step by step through process rather than pronouncement. That's how courts maintain control when strategy shifts midstream. This is only the first phase, because once a court begins reassessing its path, everything that follows is shaped by that reassessment. Outcomes don't change instantly, but direction can. And in legal battles, direction is everything. As the strategy shift settled into the system, its effects became more visible to those who know where to look, not on television, not in public statements, but in the way the case began to slow, narrow, and reorganize itself around a new set of questions. Courts are built to handle conflict, but they are not built to handle unpredictability lightly. When a legal strategy changes midstream, judges must decide whether the old map still applies. Very often, it doesn't. That realization changes tone inside the courtroom. Judges begin thinking less about outcomes and more about preservation. Preservation of process, preservation of fairness, preservation of a record that can withstand scrutiny later. That mindset reshapes how quickly or slowly the court moves next. This is where reaction becomes visible without being announced. One of the first things courts do in moments like this is reassess sequence. Which issues must now be addressed before others? Which assumptions no longer hold? Which steps, once thought automatic, now require confirmation? Sequence governs everything. If an issue moves earlier in sequence, it gains weight. If it moves later, it risks becoming irrelevant. Courts are acutely aware of this, and that awareness guides their next procedural choices. That's why sudden strategy changes are so disruptive. They force judges to revisit decisions they believed were already resolved, even if those decisions stand. The act of reconsideration slows the process and increases caution, and caution is contagious. Opposing legal teams sense it immediately. They begin operating under the assumption that nothing is settled. Arguments that were once secondary are elevated. Positions are tightened. Language becomes more precise. This is how pressure reshapes preparation. Another factor quietly influencing the court right now is the appellate lens. Judges are not only deciding for today, they're deciding for how this moment will be viewed months or years from now by higher courts. Every procedural choice creates a trail. If the court ignores a strategic shift, that choice must be defended later. If it responds too aggressively, that too must be justified. The safest path is often deliberate engagement, measured, documented, and careful. That path takes time. This is why experienced observers are not surprised by the lack of immediate public response. In high-stakes cases, speed is rarely the priority. Control is and control comes from owning the pace. Courts do this by issuing narrow procedural actions instead of broad rulings. They might request clarification. They might adjust briefing schedules. They might pause certain actions without explaining why. Each of these moves signals engagement without commitment. It's also important to understand that strategy shifts don't affect only the court. They affect the entire legal ecosystem surrounding the case. Attorneys, consultants, and advisors all begin recalibrating their expectations. That recalibration creates friction. Friction forces choices. Choices create exposure. Exposure leads to mistakes. Courts know this, and they often allow pressure to build slowly rather than resolving it immediately. This is not passive behavior. It's strategic restraint. Another subtle effect of this shift is how it reframes narratives inside the courtroom. Judges are human, but they are trained to think structurally. When a strategy changes, it reframes how earlier actions are interpreted. What once looked straightforward may now appear provisional. That reframing matters. It influences how judges read future filings. It influences how they interpret urgency. It influences how much latitude they give each side going forward. None of this requires a ruling. It happens internally, through mindset and expectation. Legal professionals following the case understand that this is the phase where outcomes begin. Too narrow, not because decisions are made, but because paths are being closed or opened quietly. That's why attention remains high despite public silence. Every day without clarity increases the weight of the next procedural move. When the court finally acts, that action will carry more significance than it would have before the strategy shift. This is how momentum works in law. It doesn't rush forward, it accumulates, and right now, accumulation is happening. The court is absorbing information, assessing risk, and positioning itself to respond in a way that maintains authority. That authority depends on appearing methodical, not reactive, which is why patience is being exercised. For the public, patience feels like delay. For the court, it's preparation. And preparation often determines outcomes more than argument ever does. As this phase continues, watch not for dramatic announcements, but for subtle procedural cues. They will tell you more about the court's direction than any headline could. Because when strategy changes, the legal world doesn't react loudly. As the legal process moves forward, attention now shifts to how the court chooses to reassert control. After periods of silence like this, courts rarely respond with dramatic language. Instead, they reestablish order quietly, often through procedural signals that only experienced observers recognize immediately. This is the phase where restraint becomes power. Judges understand that once a strategy shift has been absorbed into the system, every next step must appear deliberate. Not rushed, not reactive, deliberate. That approach protects the court from criticism and from future challenges that question its fairness or consistency. Silence, in this context, is not uncertainty, it is preparation. One of the first signs of movement usually comes through subtle adjustments. A scheduling notice that looks routine, a brief procedural order that seems technical, a clarification request that doesn't mention the broader implications at all. These are not random actions. They are how courts test stability before committing to direction. Legal professionals know to watch these moments closely. When courts choose procedure over substance at this stage, they are shaping the environment in which substance will later be decided. They are narrowing options, defining boundaries, and signaling expectations to all parties without saying so directly. This protects institutional authority. Opposing teams now face a reality they cannot ignore. The case is no longer moving on the assumptions they prepared for earlier. Preparation must adapt. Strategies must be simplified or refined. Arguments must be reconsidered with the new procedural posture in mind. That recalibration is costly in time and attention. And courts are aware of it. Allowing pressure to exist forces discipline. It reduces theatrics. It filters out weak arguments that cannot survive sustained scrutiny. Over time, only positions grounded in structure and clarity remain viable. This is how courts quietly take control back from narrative. Another factor shaping the next phase is how much flexibility the court believes it still has. Flexibility is not infinite. Once certain procedural doors close, they do not reopen easily. Judges are careful not to lock themselves into positions that could limit their options later. That caution influences the pace. Publicly, this looks like delay. Internally, it's strategic sequencing. Each step is chosen not only for what it does now, but for what it preserves for later. This mindset explains why courts rarely commit during these phases. Explanation invites interpretation. Interpretation invites pressure. Pressure invites error. So courts move quietly. As time passes, the legal world begins to adjust its expectations. Early assumptions fade. New probabilities emerge. Not because anyone announced them, but because the procedural environment has changed enough to make some outcomes more likely than others. This is how momentum shifts without headlines. Eventually, a visible move will come. It always does. When it does, it will appear controlled, measured, and carefully worded. It may not reference the strategy shift directly. It may not explain the reasoning fully, but it will align with the recalibration already underway. Those paying close attention will recognize it immediately. That moment will not feel sudden to legal professionals. It will feel inevitable. As the groundwork is being laid now, every day of silence adds weight to the next action. Every quiet adjustment clarifies the court's posture. By the time the public sees a clear signal, the direction will already be set. This is why moments like this matter. Not because of what is decided today, but because of how tomorrow is shaped. Courts operate on continuity. Once they commit to a path, deviation becomes difficult. The strategy shift has already influenced that path. From here forward, every filing will be read differently. Every argument will be evaluated within a new framework. Every delay or acceleration will carry meaning that didn't exist before. That is the lasting impact. This phase does not end with noise, it ends with structure. And structure, once established, guides everything that follows. What comes next will likely seem ordinary on the surface, but its significance will trace directly back to this moment when the court paused, recalibrated, and quietly took control. Because in the legal world, the most powerful responses are rarely the loudest. And this response is still unfolding,